Hello, friends. Good afternoon. Yesterday, we discussed an important concept in contract law, which is lapse of an offer. Why is it important? Because you'll have to go back to your basics to understand this. When we started our discussion on law of contracts, I told you that in order to form an agreement, you need three things. Number one, offer, then acceptance, and then consideration. You need all three. Okay? Now, there are a few agreements where consideration is not mandatory. But forget about those agreements for now. The basic rule is that you need all these three to form an agreement. And the first thing is offer, which is the starting point of an agreement. Now, our yesterday's discussion, which was on lapse of an offer, becomes crucial in light of the fact that understand one thing, to form an agreement you need an offer first, but if there is no offer at all, then how can there be an agreement? And now link it to our yesterday's discussion on lapse of an offer. Lapse of an offer basically means that the offer has been recalled. Offer has been recalled or cancelled, which means that we do not have any offer now. So this thing is gone. Now, if you don't have an offer, then there is no question of acceptance. Okay? And therefore, there is no question of an agreement. Hence, this discussion was extremely important. And more importantly, you should be able to understand as to when do we have a valid offer, or when can we say that an offer has lapsed. Basically meaning when an offer has been recalled or cancelled. All right? And we saw that an offer can lapse in 3-4 ways. Number one was revocation. Revocation of the offer by the offerer. Now imagine if somebody is making an offer, but after that person has made the offer, he changes his mind and he wants to cancel his offer. Okay? So if I were to sell my pen to you and I make an offer to you saying, will you buy this pen at rupees 10? But after I make this offer, my mind changes. I realize that no, I like this pen. I should not sell this to anyone. So it may happen that once that it may happen that after an offer is made, sometimes the offerer would want to cancel that offer. And that is where this becomes important, revocation. Okay? And we saw that there is a limited window within which, if an offerer wants to change his mind, he can do so. Okay? So, with respect to revocation, what is that limited window? The limited window is revocation of the offer should be before acceptance is made. All right? If the offer is not revoked before the acceptance is made, then it cannot be revoked at all. Why? Because again, come to basics. Agreement is offer plus acceptance. So if a party has given its acceptance, then both the parties are bound by the offer and the acceptance. They cannot go back now. Therefore, if the offerer wants to revoke his or her offer, he or she can do so only before the acceptance is made. Once an acceptance is made, an agreement is formed. Okay, so that is the limited window within which an offer can be revoked. Now there's one more point that you should note, which is that revocation should actually reach the offeree. Now try to understand this with the help of our pen example. A makes an offer to B saying that, will you buy my pen at ₹10? Okay, and A tells B that you have 2 days to accept my offer. The next day, A decides to change. A changes his mind and decides to revoke his offer. Question is, how should this revocation be communicated to B? Or if at all, communication of revocation to B is required. Think about it. Let's say A does not tell B that the offer has been revoked. What happens then? Will the revocation be effective? Logically thinking, it shouldn't be. Because once you make an offer to somebody, you as an offerer, if you want to cancel that offer, you will have to communicate the cancellation of that offer also to the offeree. Otherwise, how will offeree know that this offer no longer exists? Okay. So therefore, revocation should actually reach the offeree, which means offerer should communicate the revocation of offer to the offeree. Now, in light of this, I will give you one question and I would like you to think about it. A makes an offer to B. But before B accepts the offer, A sends his revocation to B by a letter. So basically, A is revoking his offer and he has sent a letter to B. While B receives the letter, he does not open it and therefore does not read the letter. Which means that B does not know that the offer has been revoked. After a few days, B accepts the offer. Okay, since B was not aware of the fact that the offer has been revoked, B has communicated his acceptance. But A tells him that offer had already been revoked. So there is a dispute now. B's answer to A's contention is that I never got to know that the offer has been revoked. And we saw in the principle that revocation should reach the offeree. Question is, what is the meaning of reaching the offeree? Okay, if B receives the letter and does not read it, does it mean that the revocation never reached the offeree? That is what I would want you guys to think and give me your answer in comments. All right. So we discussed the first manner in which an offer can be revoked, which is in which an offer can lapse, which is revocation of the offer by the offerer. The second point is lapse of time. All right. So the second manner in which an offer can lapse is by way of lapse of time, which means that if the offerer has given a specified or a definite time to the offeree to accept the offer, then the offeree has to accept the offer within that time. Okay? It means if the offerer has given a definite time to the offeree to accept the offer, the offeree should accept within that time. And if the offeree does not accept the offer within the time given by the offerer, then the offer lapses. If NLSIU gives you 7 days to accept their offer, and if you don't convey your acceptance in 7 days, then NLSIU's offer lapses. Suppose you give your acceptance on the 8th day. That is not a valid acceptance because the offer was valid only for 7 days. This is when the offerer has given a time. Okay? If the offerer has not given any time, which means that there is no timeline in the offer within which the offeree has to accept. In that scenario, offeree has to accept in a reasonable time. Now we had seen yesterday that there is no definition of what is a reasonable time. It will need to be determined based on the facts of the case. But just think like this: if whatever a person of average intelligence thinks in the facts of the case, that okay, this much is reasonable time, that will be deemed to be reasonable time for the purpose of acceptance of the offer. Okay, so if I want to sell my pen to you and I make an offer to you, but I don't mention the time within which you have to give your acceptance, and you give me your acceptance after a month, question: has your acceptance been given in a reasonable time? The answer will most likely be no, because I, as an offerer, cannot be expected to wait for 30 days to get your acceptance. Reasonable time in this scenario would have been a few seconds to a few minutes and not 30 days. Okay, so that is the case when an offer lapses due to expiry of time. First scenario we saw was when the timeline is explicitly given by the offerer in the offer. In that scenario, the offeree has to give his acceptance within that time. Second scenario was if there is no timeline mentioned in the offer, then the offeree has to give his acceptance in a reasonable time. Okay. Third way in which an offer can lapse is when there is a failure to fulfill a condition precedent by the offeree. Condition precedent simply means that before giving acceptance, the offeree has to fulfill a specified condition. Okay, so if I want to sell my bike to you and I tell you that if you want to purchase my bike at rupees 50,000, if you accept my offer, you will have to deposit 10,000 rupees immediately as security deposit. Okay, and if you don't deposit 10,000 rupees, then your acceptance will not be valid. You choose to accept my offer. You tell me that, yes, I'm willing to buy your bike at 50,000 rupees. Let's close the deal. I accept your offer. But you don't deposit 10,000 rupees. Question: is your acceptance valid? The law says no. Because when I made this offer to you, there was a condition precedent. What was the condition precedent? To deposit rupees 10,000 as security deposit. Okay? Now, you as an offeree had to fulfill this condition precedent for your acceptance to be valid. Since you did not deposit rupees 10,000 and merely conveyed your acceptance, this is not a valid acceptance. And considering you did not fulfill the condition, therefore my offer lapsed. I'm no longer bound by my offer. Okay, the last way in which an offer can lapse is by way of death or insanity of the offerer. Now we had seen that this will be applicable when the offeree has knowledge of the death or insanity of the offerer before the offeree gives his acceptance. Gives his acceptance. It means that when the offer, so when, let's say I make an offer to you, okay, to sell my bike. Yeah, so if I make an offer to you saying that, will you buy my bike at rupees 50,000? After I make this offer, let's say I die, and you have knowledge of the fact that I have died, and you have still, you did not communicate your acceptance, or you did not give your acceptance before I died. In this case, my offer has lapsed. But if you had already given your acceptance, okay, before I died, then the offer does not lapse. Or let's say I died, but you did not have knowledge of the fact that I died or I became insane, and after that you gave your acceptance, then also the offer does not lapse. Okay, so we'll have to look at 2-3 elements here. Number one, when offerer dies or becomes insane and acceptance is not made before the death or insanity. In this scenario, offer lapses. That is the first situation. Second is when offerer dies or becomes insane, but acceptance was given before death or insanity. In this scenario, offer does not lapse. Okay, because acceptance was given before death or insanity. Therefore, we have a valid agreement. Third situation, when offerer dies or becomes insane. Acceptance is given after death or insanity. But the offeree was not aware of the death or insanity of the offerer. in this scenario, offer does not lapse. So the crucial distinction is knowledge. If the offeree had knowledge of the death or insanity and he gave his acceptance after the death or insanity, then the offer lapses. But if the offeree did not have the knowledge of the death or insanity and he gave his acceptance after the offerer died or became insane, then the offer does not lapse. It is a valid acceptance. Okay. So these are the 4 ways in which an offer can lapse. Now we will talk about revocation of acceptance. So when we started our discussion, I told you about the fact that for an agreement you need both offer and acceptance, and we started our discussion with lapse of an offer, where one of the ways in which an offer could lapse is revocation, which means that after an offer has been made by the offerer has a limited window within which he can cancel his offer. Similarly, when you look at acceptance, there is a similar kind of time window available to the offeree within which the offeree can cancel his acceptance. Because it may happen that after an offeree has given his acceptance, he can change his mind, thinking that no, I shouldn't have agreed to this offer. This was a bad deal. And now I want to cancel my acceptance. He can do so by law, but there is a limited time window within which the acceptance can be cancelled, and this is what we will discuss. And before we start our discussion on revocation of acceptance, remember one thing, okay? Once acceptance is given, once acceptance is complete, it is irrevocable. It means that the moment the offeree's acceptance is complete, we have a valid agreement in place. Okay. Now it indicates that the offeree will have to withdraw his acceptance before it is complete. So we know that after an acceptance is complete, there is a valid agreement. Therefore, if the offeree wants to cancel his acceptance, he will have to do so before the acceptance is complete. All right? Which means that the revocation of acceptance has to reach faster than acceptance. Now remember go back to our postal rule example. We had seen that in that case, when NLSIU made an offer to you and you posted your acceptance was complete vis-a-vis NLSIU the moment it was posted. But it was not complete vis-a-vis you, the offeree. And you had time until the acceptance reached the offerer NLSIU. You had time until then to cancel your acceptance. Let's write it down again to understand. NLSIU and your example. NLSIU had made an offer on 13th Jan. You posted your acceptance on 14th Jan. Okay. Acceptance reached NLSIU on 15th Jan. Alright. So in the NLSIU example, you posted your acceptance on 14th Jan. NLSIU received your acceptance on 15th Jan. Question is, when is your acceptance complete? Because the principle says you can revoke your acceptance as an offeree only before it is complete. So question is, when is acceptance complete? We will look at all the scenarios. Number one, we will talk about postal rule. And second, we'll talk about instantaneous mode. We had seen that an acceptance is complete in postal rule at two different times. Number one, when is acceptance complete vis-a-vis the offerer? It is complete the moment acceptance is posted, and vis-a-vis the offeree, the acceptance is complete only when it reaches the offerer. Okay, which means that the offeree has time. The offeree has some time to cancel his acceptance. So if offeree posts his acceptance today and his acceptance is supposed to reach the offerer tomorrow, then the offeree has 24 hours from today until tomorrow to cancel his acceptance. Now, how can he cancel his acceptance in this scenario? He will have to send his revocation through a faster mode of communication, which means that his revocation of acceptance should reach faster than his acceptance. So if his acceptance is supposed to reach tomorrow, his revocation of acceptance will need to reach before that. Okay. And in instantaneous mode, we know that acceptance is complete when the acceptance reaches the offerer. Okay, so when we are talking about instantaneous mode, the time window is actually quite short, because let's say if you are communicating with me over a phone call and I make an offer to you, will you buy this pen for rupees 10? I make an offer and you convey your acceptance immediately, saying that yes, you accept. Now I hear those words in real time. I hear your acceptance in real time. And the moment your acceptance reached me, your acceptance is complete. Now you cannot revoke it. Therefore, revocation of acceptance becomes very difficult when we are talking about instantaneous mode of communication. And it actually is applicable mostly in cases of postal rule, when there is some time window available to you, because postal rule says that the offeree has time from when the acceptance is posted till the time the acceptance actually reaches the offerer. This time window is available to the offeree to revoke his acceptance. And revocation, how can the revocation happen? Revocation will have to reach faster than acceptance. That is the rule about revocation of acceptance. All right. So you will have to remember all these things that we've studied so far, because today is the end of our offer and acceptance series. From tomorrow, we are going to discuss a new concept called consideration. And if you remember, we had seen that agreement is offer plus acceptance plus consideration. So once we are done with consideration, we will be able to fully understand what an agreement is. By now, you have understood what is an offer, how is an offer made, how many types of offers are there, how can an offer lapse, what is revocation of offer. Similarly, you saw what is acceptance, how does an acceptance need to be communicated, who can communicate an acceptance, to whom it should be communicated, all those things we saw. And today we discussed about revocation of acceptance. And in very simple terms, it means that before your acceptance reaches the offerer, you as an offeree can revoke your acceptance. Okay. So from tomorrow we'll start our new series on consideration, and consideration is a very tricky area. Many people understand what an offer is or what an acceptance is because we keep seeing this in our daily life. But not many people understand the concept of consideration. Some think that consideration is only money, which means that anything in monetary terms can only be consideration and not anything else, which is an incorrect understanding of law. Okay, so I would request you to attend all the classes, pay very close attention, because I can promise you that my style of teaching will, I'm not promising that you will be able to memorize each and every section of Indian Contract Act. Please remember that. And that is not my purpose. And that is not even the purpose of CLAT exam. They are not checking your legal knowledge. They are checking your legal reasoning, which means that they want to know how good you are at understanding these legal concepts. And how do they check that? They will give you a passage, they will give you a concept, and then they will see whether you can apply that principle which is there in that passage or concept to the facts at hand, and can you make a decision based on your understanding of that principle of law. Okay, and that is my style of teaching. And if you complete this course, I can promise you that not just for CLAT, when you go to law school also and you study these courses, you will be able to relate as to how far ahead you are, because I want to build thinking skills in you. Rest, everything is easy. Anybody can read a book, anybody can memorize, but not everybody can analyze, which is what the purpose of this course is. So, all right, enough gyan for today. Let's meet tomorrow. Thank you so much.